Okay, I just want to make sure I understand. You're now asking to withdraw specific pages from those boxes of records, but you're still asking to omit these pages, and when I say these pages, I'm talking about 1, 2, 3, 4, 5, 6 pages of notes and drawings, the red portions that are circled.
Yes.
Okay. State, do you want to be heard on the defense withdrawing certain pages from the records? And have you had a chance to pull those for me?
No, because for some reason, I'm numbering the box.
Mr. Sachs, can I see those?
Pages. Do you have them? The pages you.
Judge, there may be other pages that we, right, we're gonna go through and we will, I mean, the jury's not gonna be looking at these today. Unless they're gonna try, in which case we need to deal with it, but we are gonna go through and move to withdraw from evidence whatever pages there are. I mean, we can go through it ourselves and review them.
What are we doing here? State, do you want to be heard?
Yeah, what are they withdrawing?
They don't know. This isn't working. You all, I understand sometimes after the fact or what have you, you need to withdraw something, but you're saying you want to admit this whole table of evidence but then you want to withdraw some of it, but you don't know what it is that you want to withdraw. So how am I supposed to rule?
Well, we can
That it's admitted
defer.
subject to all the pages that you want to withdraw, but what if the state objects to some of them and they need argument on it?
Well, we can leave them for now, Judge. We don't intend to show the jury all of these records now. We can go through the pages, let the court know, let the state know, and then we can come back at another time and, like Monday when we come back from the break next week and argue that.
Then I don't think that the boxes should be received into evidence today.
Okay.
I think that argument should be made prior to. If you want to lay the foundation through this witness, when you lay the predicate foundation, if you can, the relevancy, and so on and so forth, and then put it in at another time through another witness or not.
Okay.
I don't have a problem with that.
Well, if they're not going to show her notes?
That's something separate.
I think for now, we're just talking about the boxes of school records that are on the table to my left.
Well, those boxes contain, what I told the court, that, and they'll probably be admitted. And let me read it to you. A student was brought to student services after teacher observed a student write "kill" on a piece of paper. Student also told another student that he drank gasoline last week and was suspended for fighting. And he had a backpack with FNs on it and a swastika in big letters on his backpack for everyone to see. So, it's all kind of tied in, and on cross-examination, I'm going to ask her if she was bullied, and is this the swastika part of it?
So it's your position that the teacher was bullied by the defendant in part with the use of swastikas?
Yes.
Judge, there's no evidence that Mr. Cruz, there is evidence of him being aggressive toward her, but the swastikas, there's no evidence that he was doing that in an effort to bully her.
But it wouldn't be what he intended, it would be how she received it, and I don't know what her answer is.
We can ask her.
In other words, if I start flashing swastikas at you in an attempt to bully you, and I'm not meaning for the swastikas to be bullying you, I'm just trying to be aggressive, but you receive what I'm doing as using swastikas to bully you. You see what I mean?
Okay, well, we can ask her. Oh, yeah, maybe we need to mute. She's actually listening. I believe. Oh, it is me? Okay.
Your Honor, let's do a proffer, see if it's part of it.
Also, Judge, we have filed motions. We have not received a ruling. We would have voir dire the jury on this issue had we known these were going to come in, it's not relevant, it's more prejudicial than probative, so we're renewing all of those arguments about this particular symbol is not, it's not relevant and it's overly prejudicial.
All right, with regard to the packet of 1, 2, 3, 6 pages of notes, I find that the prejudice with the word swastika and the drawings does not outweigh the probative value, and here's why. There's a drawing that says N is for Niger, B is for bitch, A is for anus, F America, suck balls, and then there's pictures, little stick people shooting each other in the face. The small swastikas in the middle of the drawing is honestly, in my opinion, the least prejudicial or one of the lesser prejudicial markings on this paper. In the totality of this drawing, there are horrible things all over it, and removing those drawings in your case, when you are the proponent of this evidence, I disagree with your argument that the prejudice outweighs the probative value in considering all of the drawings. The third page looks like a helicopter shooting somebody on the ground with little stick bodies on the ground, and 3 or 4 other stick drawings of somebody shooting somebody else, which appears to be right in the face. 1, 2, 3, 4, 5, and then at the top right, there are scribbled, I guess, what are swastikas, and then I think you might have, oh no, this is a different page. No, I think you gave me the same,
Some of them seem to be duplicates in the packet.
this looks like it's the same page
Yeah,
twice,
I think there are some duplicates in the packet.
so I don't need to repeat all
No.
those things.
No.
Also, there's a note on one of these pages, I know more than your something life as a human, and then it has it looks like a Jewish star and then a Nazi symbol and then perhaps a cross. To me, that looks like it relates to the statement just before it. I know more than your, I don't know what it says, pathetic life as a human, and then it seems to indicate different subgroups of the population. All right, so if you're intending to admit these drawings and notes into evidence, I am denying your motion to redact these portions. Also, isn't there another, what is the symbol on the drawing page? It's right here. I don't know if that's a,
I'm sorry.
sure. I don't know if that's an attempt to be a Jewish star. Looks to me like it, based on the, if you look at it in conjunction with the other pages, that it's a Jewish star next to a Nazi symbol.
Not exactly a Jewish star, but
Well,
just a.
I don't know.
all right.
So I have 2 requests. Based on this court's ruling and all of the previous litigation, I would ask for a little bit of time for us to consult about how we want to proceed. And second, I have a question. If the defense chooses not to introduce this, are you going to allow the state to introduce it on
I
cross-examination?
don't know, because I have to hear what the witness is gonna say.
Then
cross-examination is to impeach the credibility of a witness or to show some type of bias or to bring out some type of detail that was not brought out during direct examination. I have no idea what this lady is gonna say. Certainly, as I said, if she feels that those types of drawings and the specific things that are written on those affected her, and then yes, I'm going to allow them. I mean, I'm not clear why when there's all of these different hate groups on there, why the defense is concerned only with the Nazi symbol. Is this, I mean,
it's one of the most prejudicial hate symbols in the world, so
well,
that's what
so
we're concerned
is the
about.
N-word, and so is, I don't know, there's a lot of other things on there that are,
So Jed would ask for a few minutes for us to consult, and I would also ask that the court order that if the state believes that it is entitled to bring in this evidence, if we choose not to, after consultation, that we go sidebar first and allow us to make argument and probably move from this trial.
okay. I am not going to, this is not how it works. If you all want to put forth evidence, probative evidence that you believe is something that should be submitted to the jury in your case in chief, I'm not going to go through and piecemeal it and ask the state to tell me exactly what questions they're going to ask and prejudge the evidence. This is what happens. If you call a witness and there are things that the witness may or may not have to say that are prejudicial to your case, you have to consider that before you call the witness.
I understand that, Judge. What I'm asking is after she testifies on direct examination, if the state believes, if we do not enter that evidence and the state believes it can enter the evidence, then I would ask that we discuss it first because we may have objections to put on the
Okay,
record.
that's fine.
Okay. And
So-
we have a few minutes to consult.
Sure, I'll put the white noise on. You can let me know when you're ready.